Welcome to a Practice Pro CPD, brought to you by LAWPRO.
All right, thank you, Deirdre. Thank you, Sandra. Thank you, everyone at the TLA. And thank you, everyone, for joining us here today. My name is Sean Erker. I'm the legal writer and content manager with LAWPRO. I work in the Claims Prevention and Stakeholder Relations Department. And this is part of our Thursday Tips with LAWPRO and the TLA series. So I'm speaking to you from Toronto, which is also where the offices of LAWPRO and the Toronto Lawyers Association are located. I respectfully acknowledge that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now home to many First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Now, as this meeting is virtual and we're not all gathered at the same space, this land acknowledgement may not be the same for you as it is for me. And so if that's true, I would encourage you to take some time to learn about and acknowledge the traditional territory that you are on. Some resources for doing that include the website native-lands.ca, or you can contact a friendship center for guidance. So we thank the First Nations people who lived here and continue to live on these lands for sharing them with us in peace. So this program is called Client Management and Effective Client Relationships. And today I am joined by some excellent speakers. I'm very excited about this program. I'm joined by Rachel Sachs, who's a lawyer for older and aging advocates with Sachs Law. Joined by Amer Mushtaq, who's managing partner with Formative Law, LLP. Stephanie Ostrom, who's a partner with Elm Law, and Sophia Vankalwala, who's communications counsel with LAWPRO. And this program is going to be divided into three areas of discussion. So first, we're going to be discussing the start of the lawyer-client relationship. Now, this involves retainer letters, setting expectations, and that is going to lead into a discussion of fees. So we're going to give some tips on how best to prepare your retainers, how best to prepare any kind of engagement letters or disengagement letters, and how that is going to move forward. This is going to lead us into a discussion of collecting retainer fees, replenishing retainers, and how best to collect unpaid fees that are owing. Second, we're going to be talking about managing the lawyer-client relationship, particularly if there is the possibility or existence of a relationship breakdown. Now, obviously, from LAWPRO's perspective, a breakdown in the lawyer-client relationship can lead to potential claims. And so this is obviously a subject that we are concerned about, but obviously every lawyer wants to maintain the best possible relationship with their client because they not only want to have a very successful current project, a current file, but they want future work and the client to recommend them to other people. And then finally, we're going to talk about how cultural competency and EDI matters can impact communications and can impact the lawyer-client relationship. This is going to talk about certain expectations and biases that we all have that may actually undermine our ability to communicate with our clients and maintain these positive relationships. So to start off with, I just want to do a little bit of housekeeping stuff. There is a Q&A in the Zoom program. If you have questions, please put them in the Q&A box. We will be monitoring that, and we're going to leave some time at the end of the program to try to cover as many of those questions as we can. Now, this program is eligible for 90 minutes of professionalism with the Law Society of Ontario. It's also eligible for one risk management credit with LAWPRO, which is worth $50 off your future insurance premiums. After this program ends, you will be receiving a survey from the TLA asking you what you've thought about the program, what you liked, what you didn't like. We encourage you to fill that out and send it back to us because it helps us improve these programs. It helps us give you the kind of content that you're looking for your practice, and it helps us know what we should be preparing in the future. Finally, this program will be available online at practicepro.ca/CPD, where all of our previous programs are available and all of the program materials are available for these programs. You can find online versions of all of our previous videos, CPD programs, and you can find the online version of this program in a few weeks. The materials for this program are also available through the chat. The link should be there. So you can go to either practicepro.ca/CPD or go to the link in the chat. So to start off with, we're going to talk a little bit about retainers. Now, from LAWPRO's perspective, this ties into one of our main subjects of communication, which is we want to tell people all of your communications with your client need to be written down. If you have a conversation with your client and anything important is discussed, you should be writing that down and creating documentary evidence of what the instructions were from you to the client, what the instructions were from the client to you, what decisions were made, what decisions were not made. And obviously, all of these conversations that end up being documentary documentary evidence of those conversations start with the retainer. So at the beginning of the relationship, your retainer is going to allow you to tell your client what you are going to be helping them with, but more importantly, what you're not going to be helping them with. At LawPro, we see a lot of claims that come about because clients have a different expectation about what matters the lawyer will be handling than the lawyer actually knows. For example, we sometimes see real estate matters where a lawyer will not be handling the HST implications of a real estate transaction. Instead, the lawyer expects that a broker or a tax expert will be handling that. Unfortunately, if an HST matter arises and it's not properly dealt with, the client may take a claim against the lawyer and say, even if you weren't planning to handle HST matters, that was within your purview of responsibility. And so having that laid out in a retainer helps protect the lawyer from that kind of claim risk in the future. Any kind of communication can lead to these miscommunications. And that's why writing it down helps clarify for both the lawyer and the client what exactly you have decided and what exactly you are talking about. I always like to say that sometimes a client comes into a conversation with a lawyer with certain expectations. They might want to pursue a certain strategy. That strategy might not be the best strategy. It might not be in the client's best interest. And the lawyer might say, well, instead of doing A, how about we do B? And we'll leave A for now, and maybe we'll come back to it. And the lawyer might say something like this because they don't want to discourage the client. They don't want to try to argue with the client. But what happens is that the lawyer believes that they said, we're not going to do A, we're going to do B. But the client believes that the lawyer said, we're going to try B and we're going to do A later. And so in all of these circumstances, actually writing down what was decided, sending it to the client, letting both of you know that you're on the same page is extremely important. Another reason why putting all of these things in writing at the start of the relationship in the retainer is extremely helpful is because it can help prevent certain circumstances such as fraud. Now, this is a new policy that LawPro is pursuing to try to avoid social engineering frauds that are targeting lawyers. I'm going to talk a little bit about this. So social engineering is an increasing threat against lawyers where fraudsters will target lawyers, particularly because they have access to trust funds and trust accounts. And what happens is that they will gain access to a lawyer's email communications. This can be through hacking, or it can be through phishing emails, getting a member of the staff to click on a malicious link of some sort. And you don't even know that it happens because the fraudster is sort of lurking in the background, reviewing all of the communications. And they find out that the lawyer is going to be engaging in a transaction. And for example, if it's a real estate transaction, perhaps a large amount of money is going to be transferred once the transaction finalizes. The lawyer has a certain bank account that they are expecting to wire these funds into. And the fraudster, who's watching all of these communications, will send a last-minute email that says, lawyer, this is the client, and it will look exactly like an email from the client. And it says, we've changed the bank account. You now need to send it to the account number such and such and such. Please do it immediately because we need the funds to pursue other matters. The lawyer, believing that they are acting on behalf of their client, will send the money to this new account, not knowing that the new account is actually a fraudster's account. And once that money goes out the door, it might be lost. Now, LawPro is advocating now that all lawyers put their financial transaction instructions within written agreements, and if possible, within the initial retainer. And so the initial retainer can include some language that says, as your lawyer, I will only be transferring funds with respect to the following instructions, where we will be using the following account number that you have provided to me, and you will only be sending funds to the following account number that I am providing to you. And if those instructions change, they need to be verbally confirmed. So that means getting on the phone, talking to the person, and saying, I just received this change of instructions. Are these accurate? Are these true? And so we've put into the chat here a link to our social engineering resources. And on those resources, you can find some draft language to put into your retainers to try to protect you against these fraud threats. And you can also find some language to put into an email to your clients if you already have a retainer that will alert them to these concerns and will provide them with the information they need in order to communicate with you about any change in financial instructions. And following these guidelines will ensure that your LAWPRO insurance is maintained at the $1 million level per claim. Because starting January 1st, social engineering claims will have a sublimit of $250,000 attached to them, unless, of course, all of the lawyers participating follow these guidelines, wherein they put these instructions in the retainers or another written agreement, and they also confirm any change of instructions verbally. So to review what we've just discussed, you can go to the social engineering page on practicepro.ca. And so that is a bit of an introduction, but now I want to turn it over to Amir, who is going to talk more about drafting your retainers and also talk about setting fee expectations, replenishing those fees, and then of course, collecting fees. So if Amir could turn on his camera, and I will hand it over to him.
Thank you, Sean. Hello, everyone. So we'll talk about retainers and also the monetary retainer aspect that I will talk about. Before we get into a bit of in-depth in these discussions, I want to say that most lawyers treat retainers as how we treat release agreements, right? So, and so your treatment of retainer agreement varies based upon how experienced you are in your practice. If you're a new lawyer, you would treat retainer agreements differently. If you have more experience in dealing with clients and setting up these relationships, your approach is slightly different. And then also the kinds of issues that you have experienced with clients or have seen other lawyers having such experiences with clients and conflicts, you approach retainer agreements differently. So I sort of equated with how we treat releases, and if you can go back to your earlier years when you for the first time you heard about what is a full and final release, and your partner or whoever senior associate you were working with, they gave you a copy, and they went through this old archaic language. Talking about I release, quit claim, I forego every kind of claim and everything, and all those languages that you see in a release, and you kind of hold dearly to that language because what you realize is that it has been created over decades and decades of work and experience of other lawyers. So you don't, as a junior lawyer, when you are entering into or negotiating a release with the other side or other party, it's very hard for you to accept any changes into that release agreement because you feel like maybe you're losing some ground, maybe you're going to write something or agree to something that may have further implications that you have anticipated, right? So and then as you get more experience, you realize that release is just like another contract, and it depends upon the circumstances of the matter that you're dealing with and what should be in the release and what shouldn't be in the release, and it becomes a bit more a document that is a bit more dynamic. Same is our approach with retainer agreements. And I can tell you from my own experience that when I started my practice as a sole practitioner, coming from a larger law firm, I had the retainer agreement from the large law firm. And so it was an extensive agreement, and obviously it was designed for all kinds of major national, international clients. And so when you look at that retainer agreement, excuse me, it has a page about disbursements, and there was a whole page and there was a list of things which included, evening meals, and it included travels out of province, and renting a car, and all those kind of things, and they were part of all those disbursement descriptions. And when I started as a sole practitioner, a lot of that didn't apply to me. I could not possibly ask a client to pay for my meal in the evening just because I'm spending extra hours on their file. But that was part of the retainer agreement. And when I'm talking to my clients who are layperson, who are not as sophisticated corporate entities, I have to send a large agreement to them and ask them to sign. And then they will come back to me with questions, right? And say, well, what about this? And what about meals? And what about these travels? And then I had to explain it to them. And then my standard response will be, oh, the retainer agreement is standard, and this is the language, but most of it may not even apply to you, so not to worry about it. And so now I'm kind of trying to ask them to sign it, trying to assure them that a lot of the stuff about disbursements or other things may not really apply to their case. And so at the end of the day, they may be partly confused, they may be partly satisfied, and then at the end of the day, they just want to proceed with my services, and they'll sign the agreement. And it wasn't long till I realized that the retainer agreement that I used at a major law firm was not appropriate for the circumstances of my retainer with clients who were in different circumstances. And so the retainer agreement became modified at times. It became much shorter, not losing the essentials that are required in a retainer agreement. So I think what is important to take away from this is that we all have standard retainer agreements, and we expect most of our clients to just sign them so that we can move on. Here's our standard retainer agreement. It describes how the fees are charged. It describes how the relationship is going to proceed. It describes what services we're going to provide, how we're going to provide. All of those expectations from both parties are set out. And so we're hoping that they could just sign it quickly so that we can move on. And a lot of times clients may have a lot of questions, and so those need to be addressed. So I think it is not a bad idea every time you're sending out a retainer to a new client, that you quickly review your retainer agreement and quickly review the circumstances of that relationship and see whether that retainer agreement is appropriate in the circumstances. And there may be a line or two here and there that you may need to add or change, which will fit the circumstances of that relationship. And I think that's okay to do. It's not a bad practice to review your retainer agreement with a fresh set of eyes every time you're entering into a new relationship. And quite frankly, it does not require a lot of your time, maybe 5 minutes, 10 minutes to have that review and then figure that out. So that's sort of the starting point that I wanted to lay out, that that we should not treat our retainer agreements as this static piece of document that needs to be imposed, and the expectation on the client should be that they should sign it. So number one. Number two, what we'll discuss today, what I will discuss and my colleagues will discuss, a lot of it is our sort of subjective experience of how we have dealt with our clients over the years, and also our knowledge from talking to other lawyers. And your circumstances may be different. And so the guidelines and the discussions that we will have today are really guidelines for you to sort of take away and then apply in your own circumstances and see what fits and how it fits. And of course, if you have any questions arising while we have this discussion, please ask us, and then we will get into it in more depth. I think what we'll try to do today is that we will go into the retainer agreements and from my side, the monetary retainer part of it in more depth. Let's dig deeper. We understand what a monetary retainer is, at least most of us do. And so we will get into a bit, nuanced issues to see what kinds of issues that I have experienced in my practice, what kind of things that I've thought about based upon the kind of practices that I've had over the years. And then maybe I can add some value to your thinking process, and then you can apply that. But let's try to dig deeper into this discussion so we can benefit from it. So the larger part that Sean has covered, and we all know from our experience as lawyers, is that communication is the key part. And it's not only in practice as a lawyer, but in our lives, in all kinds of relationships that we have, private and public, and in terms of professional relationship. Communication is very important. And we as lawyers, we deal with words and we deal with written and spoken words. So there should be an expectation that we should impose on ourselves that when we speak or when we write, our communication is clear. What we are trying to say to someone, they understand it in the way that we're saying it, and we choose our words carefully. And then similarly, we understand what another person is saying. We're able to put ourselves in their shoes, understand their circumstances, whether they are cultural, whether they're professional, whether they are, in any kinds of their background. We're able to quickly understand their circumstances and understand what they're trying to communicate so that we can respond to that effectively, right? So that's sort of the larger theme, and it applies in all areas of our client relationship. But with respect to the retainer agreements, again, it's a start of a relationship. The more clear we are, the more open and transparent we are in terms of the relationship that we're getting into with our clients, the less questions the client would have for us during the course of our relationship, and then the less disputes will arise with respect to that relationship. One of the issues that I want to talk about today is monetary retainer. So the first question that you should ask yourself is that, should you ask for a monetary retainer, right? And so is that something that you should ask for? And then what are the factors that you should consider in deciding whether to ask for a monetary retainer? I'm going to give you some ideas, some thoughts that you may need to consider in deciding whether a monetary retainer is warranted in the specific relationship that you're entering into. First thing that I can suggest is that you should think about what type of fee structure are you going to have with that client. So by that I mean, are you entering into an hourly fee structure? Are you suggesting a fixed fee structure for certain steps in the process and the legal services that you're providing, or are you entering into a contingency fee arrangement? So those three have differing treatments based upon how much monetary retainer you should ask for or not ask for. With hourly fee, as you know, the expectation is that you work certain hours, you send the invoice to the client, and the expectation is that the client will pay that fees within a certain time period, usually within 30 days after receiving that invoice. And so hourly fee, do you require a retainer, monetary retainer fee in that circumstance? Something to think about. For fixed fee arrangement, your approach may be different. Maybe you are working on a small project, and maybe you expect the entirety of the fees to be paid upfront for you to complete that project. Or maybe you think about certain percentage of fees pays as a monetary retainer. So for example, 25% of the total fixed fee amount you would like to be paid upfront, and then you will proceed with providing your services. And then in contingency fee arrangement, as you know, that as we all know, that in contingency fee, your fees are dependent upon the success of the case. And so in those circumstances, does it make sense to have any monetary retainer? And if it does, what are those circumstances where you ask for those monetary retainer agreement? So first thing to consider is what kind of fee structure you are entering into with that client, and that will play a role in determining whether to ask for a monetary fee retainer or not. The second part that you want to think about is what kinds of legal issues you are dealing with. What kind of legal services are you providing? If your practice is primarily based on personal injury, your monetary retainer fee approach would be different. If you're in employment law or human rights law, approach may be different. Criminal law may have a different approach. Family law. Similarly, in commercial litigation, the approach is different. If you are a corporate lawyer and providing services to corporate clients, your approach may be different. Even in corporate law, if you're providing, let's say, services for securities matter or public offering or startup companies, how do you deal with monetary retainers? The approach is different. So I'll touch upon some of the areas. Obviously, I practice employment law, and so I can tell you from my experience. So a small law firm, we're two lawyers. We practice employment law for more than 15 years. And so most of the clients are plaintiff side clients, and then corporate clients, but not majority of them. So with respect to plaintiff side employment law practice, the general approach is that you either do not ask for monetary retainer, or you ask for a very little amount of monetary retainer at the outset. And why is that? Because in most of employment law cases, and especially with the cases that are wrongful dismissal cases, where your claim is that you are challenging the amount of money that has been paid to your client, who is a plaintiff, at the time of their termination. So you're saying the money that was paid was insufficient, my client is entitled to more, so I'm taking the defendant, the employer, into court. And so in that circumstance, the chances are that when the matter is resolved, the additional money will come from the employer, from the defendant, and you will either get some part of your legal fees or all of your legal fees paid by the employer. So in those circumstances, and then you are also mindful that your client is the one who has lost a job, so they may not have a source of income. So in employment law circumstances, it is not uncommon for employment lawyers not to ask for a retainer fee at the outset, or ask for a very minimal, $500,000, $2,000 kind of retainer fee to start the process, and then you understand that the process will eventually lead to the payment of your fees, and it will be all fine. So that's sort of the approach. In criminal law, the approach may be different. If you are dealing with if you're defending a client who has a potential criminal charge against them, then you may ask for certain retainer fee to prepare for their case and proceed with that. Similarly, in corporate circumstances, the approach may be different. In real estate, the approach may be different. So the important takeaway here is that think about the type of legal issues that you're dealing with, and what kind of monetary retainer do they justify, and then you should proceed on that basis. Another aspect that you should consider is the nature of your relationship with that client. Is this a client that you are, is this a new client, or is this a long-standing client? You may have to enter into different retainer agreements with the same client for different kinds of services. And so do you want them to provide a monetary retainer each time you are providing some services to them, or not? And that depends upon your comfort level with that client. And then if it's a new relationship, should you start off by asking for a monetary retainer? Other things that you may consider is that, is your client a public sector client, right? And so for my clients that are public sector clients, I do not ask for monetary retainers, largely because of the setup, the way the monetary retainers would work with public sector, right? So they have to go through a lot of, detailed processes of getting approvals and stuff like that. And I know at the end of the day that it is not difficult to get your legal fees paid from a public sector client. So it's not a concern, and I would not ask for it. So all of these things, who is your client, may also determine what kind of monetary retainer you would like to ask. Another thing to consider is the type of representation that you're providing. And by that, I mean, are you a lawyer of record? So if it's a litigation file, for example, and are you a lawyer of record, that may change how you would like to deal with monetary retainers. You may be providing limited scope retainer services. So I work sometimes with self-represented litigants, and the scope of services that I provide is very limited. Let's say that I'm arguing only one motion for a self-represented client. And in most of those circumstances, this is a very specific one-off relationship for a very specific service. And, my practice usually is that, I would ask for the entire fees up front to be put in the retainer. But you can have, depending upon how much the fees may be, you may decide to have certain percentage of that fee be paid as a monetary retainer for your relationship. So the type of representation that you're providing also is a point to consider. Another thing that I touched upon briefly is your client's capacity to pay retainer, and obviously the fees. In employment law circumstances, your client has lost their employment. Their capacity to pay at that time for a monetary retainer may not be as much. And if you're comfortable with that and you're willing to provide services, knowing that eventually your fees will get paid, then that's not a bad idea, because they don't have that capacity. Sometimes their capacity to pay on an ongoing basis is tied. I mean, I was involved with a very complex litigation many years ago, where the issues if we were successful, we would have received a large amount of judgment or settlement, depending upon where the matter ends. But my client's capacity to pay was very, very limited, very limited. But I had to do a lot of work. So I had to do work in bursts of time. So there was, one time where I'm putting in hundreds of hours, and then there are a few months go by and I'm not doing any work. And so the relationship that we entered into was that my client will pay me $1,000 a month as retainer on a monthly basis. So they're constantly sending me $1,000, whether I'm working on that month or not, and that goes into the retainer portion in the trust account. And so then at the end of the day, when they don't feel so much pressure in paying the fees towards the end of it, if we're unsuccessful or the fees are not being paid by the defendant or a third party in that case. So so those are things that you can think about and then decide what to do in terms of asking for a monetary retainer. One larger theme that with all these points you're thinking about is that what is the purpose of asking for a monetary retainer? Why do you need it? You are not a contractor involved in construction project. You don't need to go buy materials. You don't need to buy certain stuff to complete your project. So what is the need for asking for a monetary retainer? And there are a few things that you can think about. Obviously, you're not a contractor, but you may need to pay for certain disbursements, right? So you may need to hire third parties, for example, experts. You may need to pay for mediation services. You may need to pay for in personal injury, some of their medical reports and tests and things like that. And so those are the expenses that you need to be paid for. And so you're asking for monetary retainer on those grounds. But a larger part of why you ask for monetary retainer is sort of this building of this trust relationship. And I remember a partner that I used to work with, he would deal with large estate litigation matters. And his approach was knowing that a client would be capable of paying, and these are clients with large estates, his approach was to say, look, you are trusting me to help you with this case, and I'm trusting you as a client that you will pay for my fees. So retainer fee in the beginning is an approach that we can build that trust. You pay me X amount of dollars, and then I have that comfort that you are committed to this legal process, just like I am. And so it's sort of building that trust in that relationship, and that may be a reason for you for asking for monetary retainer. So what I would invite you to do is think about why you're asking for monetary retainer, apply all those factors that I have sort of suggested, and think about other things that may come to your mind about why you need a monetary retainer. Like your client may be out of the country and your capacity to recover legal fees afterwards may be limited, right? So that may be another factor. So you think about that, and then you decide whether to ask for monetary retainer, and if so, how much. I'm looking at the time so that I don't run too much beyond my time. So those are the factors. Now, once you have decided that you want 20,000, 25,000, whatever the amount is, can you ask for additional retainer fee? And the simple answer is yes. It really depends upon the circumstances of your case. So yes, you can ask for additional retainer fees. So let's say you started off with a smaller retainer fees, and now you have to hire an expert. You didn't know at the outset whether an expert would be needed or not. Now you believe that an expert is required. Either you can ask the client to pay the expert directly, or you can ask the client to pay you, and then you retain the expert. It all depends upon the circumstances of the case and what is appropriate, right? So so you can ask for retainer fee later on, right? And there are a few ways to treat the monetary retainers, and I've seen all kinds of ways to do it. One approach is that you ask for monetary retainer, and then that monetary retainer is exhausted in the initial invoices, either the first invoice or second invoice, and then the expectation is that that the client will continue to pay the invoices as they come along. So the trust is built, and now we're going to continue the relationship. Another approach, which is common, is that the lawyers will keep the retainer in the trust account. So that remains, let's say, $20,000 retainer fee. It remains in the trust account, and when you issue the invoices, those invoices are paid on an ongoing basis. So you have some comfort, some room that if the fees are delayed or they're not paid on a timely manner, then you have the retainer fee that you can use towards payment of your invoices. So that's something to think about. And again, it comes down to the circumstances of your case. You don't need to exhaust the retainer fee to then ask for ongoing payment of legal fees. Now, so broadly speaking, whatever your answer is to retainer fees, whether you want to charge monetary retainer fee or not, obviously the important thing is that your retainer agreement clearly sets out, number one, your fee structure. So is it hourly, fixed, contingency? It needs to be set out very clearly. And then your retainer agreement clearly says how much retainer fee is required, when is the client required to pay, and if there is an expectation that the client may be asked for additional retainer afterwards, then it should be in a part of your retainer agreement. And I think it's okay to state that language in the retainer agreement, that additional fees, retainer fees, may be required depending upon the circumstances and the client is expected to pay. Also, I think you should be clear about the interplay, as I said, of the invoices and the retainer fee. So if the retainer fee is going to be exhausted in the first few invoices until the retainer fee is completely gone, then you should state that in your retainer agreement. So client should be clear what is it that is expected here in terms of the use of the retainer fee towards the services. It is very important to state if and when you will issue invoices, right? So a lot of, traditionally, a lot of lawyers issue invoices on a monthly basis when the services are being provided on an ongoing basis. But I've noticed that the busier you get, the harder it becomes to issue invoices on a timely basis. And I think that's an important thing, that if you indicate in your retainer agreement that you will issue invoices and expect them to be paid on a monthly basis, then you should follow that, that commitment. And that allows you to keep collecting your fees in a timely manner, and then keeps the client on board that they have an idea of how much fees they have paid. And so just because there is an invoice out, I think somehow psychologically it's important for the client to pay, so they realize that the money is out of their bank and this is how much they have spent on that particular file, because it also plays a role in how the client makes certain decisions on certain files, right? So a lot of times, especially in litigation, the client may come and be very aggressive in their approach, and they will say to you, spend whatever money is needed, we will fight this to the end, and money is not an issue, and you feel comfortable that they have enough money to pay, and so you're not worried about it. But you're not comfortable with their aggressive approach, and you believe that there is some reasonableness that needs to come into this in this file. Then issuing the invoices on a timely basis and collecting them is actually a good approach, and it puts the things into reality. Sean, I'm going to wrap it up. So now, how to collect unpaid bills without triggering a relationship breakdown? Well, the answer is very simple. You should send the invoices on a regular basis and make sure they are collected. So I think the relationship should not be so one-sided that you are so into providing services to your client, which we normally do. We're focused on providing services. We're putting in a lot of effort into this, and we're not worried about collecting our fees because we think that the relationship is great. We're doing a great job. Client is seeing we're doing a great job. Client is sending emails saying you're awesome. You're the best lawyer I've ever met. But please keep in mind that can change in an instant. And so if you keep sending the bills on a regular basis and keep collecting, that's a good idea. If you're going to a trial and it's a litigation matter and you're about to go to trial, it's a good idea to have collected most of your fees before the judgment is issued, because the judgment may not always be in your favor. So those are the things to keep in mind. Let the client know that if the fees are not paid on a timely basis, you may need to withdraw your representation. It's a hard statement to make, but it's important. It has to be there in the retainer agreement, and clients should know about it. And finally, if your bills are unpaid, what do you do now? Do you want to sue your client? Do you want to take them to assessment office or not? That requires another full seminar, and I can talk a lot about it, not because I had to sue my clients, but I have seen those circumstances, and I know. But generally speaking, you don't want to get to that stage where your bills are not paid. And then if there is a situation where your bills are unpaid, I think the best approach is to try to work out a solution with your client. May it be giving them a discount or something for a timely payment and stuff like that, and then saving that hassle of going through that legal process, because legal processes of even suing your client and collecting the fee, that's an onerous thing that takes you away from your main service of providing services and collecting fees. So but that can be done. Obviously, a lot of us know about it, but that's all I'm going to say for now. I'm happy to answer any questions you may have specifically about your practices, about self-represented litigants, about anything that you want to think about, I'm happy to chat and give my 2 cents. But thank you very much for watching and listening. Over to you, Sean.
Thank you, Amir. And if anyone does have questions, we'll be trying to cover those at the end of the program. To build on a couple of things that Amir said from LawPro's perspective, one of the reasons why we do encourage people to get retainers at the beginning, replenish those retainers, and maintain them, obviously recognizing that not all clients have the ability to maintain retainers in the same way, and it is going to be on a client-by-client basis. But from the perspective of a claims insurance agency, we do see that the risk of claims does increase if there are outstanding accounts, if there are accounts receivable, so to speak, if there are unpaid bills, especially if there is a kind of relationship breakdown between the lawyer and the client, or perhaps the file does not go the way that the client was hoping. That can sometimes be because the threat of a malpractice claim is a negotiating position. It can also just be that from the client's perspective, they start to really try to look closely at whether everything was done exactly how they instructed it to be done, because having a large bill sometimes can be a weight on someone if they are unhappy with the outcome. So I'd just like to very quickly here put Stephanie and Rachel on the spot and ask them if they have any quick tips about drafting the retainers up front on collecting fees or establishing retainers. So Stephanie, I'll start with you.
Perfect. Sounds good. I would say that my best advice is to review the retainer agreement with the client yourself. Don't give it to a clerk. Don't give it to someone, the front staff, et cetera, et cetera. Take the time, actually go through the entire thing with them, make sure they understand it. It establishes your relationship and it establishes the respect level that you need at the beginning of your relationship.
And how about you, Rachel?
With respect to retainers, I like to have a master document. I have learned that with different clients' needs, I have needed to reiterate my retainer multiple times, and totally agree with Amber that we should look at it every time we have a new client. But have your master agreement and consider when you're making that master agreement your sort of worst case scenario or most difficult clients, and then draft accordingly. And talk about it early. Like, I like to talk about it, at the start of the consultation. I kind of lay out how the consultation is going to go, and we're going to start with how this relationship would work if you hire me.
Excellent. Thank you, Rachel. So now we're going to transition to talking about that lawyer-client relationship, especially the risk of a breakdown in the relationship. So avoiding those breakdowns, maintaining trust between the lawyer and the client, and what to do if that trust is lost from either perspective. So I'm going to hand it off now to Stephanie, who's going to talk on that subject.
Perfect. Thank you, Sean. Okay, so first of all, I just want to start by saying that I am going to be speaking to you today based on my experience in family law. That's all I've ever practiced, and you should know that there are additional concerns and considerations that you should think about when you're dealing with other areas of law, particularly criminal law. There is a really helpful section on the practice management section of the Law Society website that specifically addresses termination of retainers. And of course, you can always go back to the rules as well. So let's start with the rules. Rule 3.71 of the Rules of Professional Conduct confirms that a lawyer shall not withdraw from representation unless on reasonable notice to the client and for good cause. So that's unfortunately a little bit vague, and there's definitely going to be questions about what constitutes reasonable notice and how are we going to define what is good cause, okay? We're going to get into that. But it's important to understand that once you accept a retainer, you don't have the right to terminate it at will the same way that the client does. Okay, a termination should occur on a very limited basis. So first of all, I think we have to bear in mind best practices. The more advance notice that you can give to the client, the more reasonable it's going to be. That's why it's so important to work with the client in the beginning, well in advance of any deadlines, so that if there are any issues, you're going to know about them sooner rather than later. For example, in our office, we have a meeting booked after every single court date, and all of the relevant people are included in that meeting. The lawyer, of course, the staff member who books the next court date, any other court clerks, etc. All of those people are included in the meeting, and that's where we talk about what happened at court the day before and what are we going to do on this file moving forward. Normally in family law, we have about 4, 5, 6 sometimes 7, 8 months before we're going back to court. And so we need to maintain this strategy. We need to know, do we need more documents from the client? Do we need to ask the other side for disclosure? What are the retainer top-ups going to be necessary? Do we need to bring a motion in the interim? What are we doing on that file? That's going to form the basis of our reporting letter to the client after the court date. And that's going to make sure that that client knows well in advance of what money is going to be required and what the next steps are on the file. And that's going to hopefully prevent us from getting to any sort of breakdown in the lawyer-client relationship. Okay, so let's start with some examples of why a lawyer may need to withdraw from representation and what would constitute good cause. The most obvious one would be if this falls outside of your area of practice and the client, quite frankly, would just be served better by a different lawyer. Or perhaps you've discovered a conflict of interest on the file. Normally, these two things are going to be discovered right at the very start of the working relationship, and you're simply going to refer the client out to a different law firm. So those ones are easy. The tougher ones are the actual breakdown of the lawyer-client relationship, and those can be loss of trust. The client is consistently uncooperative, unreasonable. You can't get instructions from the client, or, of course, our favorite, the non-payment of fees. So the most important thing to remember here is that the client cannot be prejudiced by the termination of the retainer, regardless of why it's occurring. Now, with respect to loss of trust, in my experience, that normally occurs when you find out that the client is not telling you the truth. And sometimes that's not even malicious, particularly in the family law arena, because emotions color people's memories. And sometimes the client's version of events versus the objective truth are two very different things. That's why we also ask for a lot of disclosure upfront from the client, well before the other side is asking for that information, because we want to make sure that if there are any inconsistencies between the client's version of events and what objectively happened on the file, then again, we can deal with that sooner rather than later. Now, sometimes a loss of trust occurs because the client wants the lawyer to do something that would be contrary to our professional ethics, and that's going to trigger a termination of the retainer immediately. In family law, that's normally something like someone doesn't want to give financial disclosure, or someone's trying to hide assets from their spouse or something like that. Now, again, you can only work with the information that you're given, but I think it's the lawyer's job to make sure that you're going through those documents very seriously with the clients. I remind them multiple times that they're swearing to the truth of their financial statement. It has to be comprehensive. It has to be accurate. And I also remind them that if I'm asking a question, if I don't understand something, then it's very likely that a judge is going to have that same question for them, and we need to know what the answer is going to be. I also remind them that I have obligations as an officer of the court, and I can't be involved in deceiving the court in any way. But sometimes people refuse to accept the objective truth of what's happening on their file. And sometimes they have unrealistic expectations, right, about turnaround time for work. Sometimes they change their instructions so frequently that you feel like you can't rely on their instructions, or perhaps they're just MIA, you can't get their instructions completely. At our firm as well, what we found is sometimes when people are in the middle of a separation or a divorce, which is obviously a very traumatic time for them, they can turn to drugs or alcohol in order to help them cope. And therefore, we get some wild emails throughout the night and some aggressive emails. And then in the morning, there's a retraction, right? Any way you cut it, a lot of times it just becomes quite clear that this is no longer a productive working relationship, and you're not going to be able to work together in the future. In family law, this generally becomes pretty evident towards the beginning of the file, because you're working in very close contact with the client about the most intimate details of their lives, right? It's crucial that there's a really strong level of trust, particularly, I think, in family law, between the client and the lawyer, because we have to work together as a team and we have to trust each other 100%. And I try to remind the client that's for their benefit. It's not really for mine, it's for their benefit. So we do try and circumvent these breakdowns as much as possible by giving a very detailed speech at the very beginning of the relationship in the initial consult or in the follow-up meeting if the client is actually retaining. So we detail, how does our office work? How can you be in contact with us? What's the likely time for a response when you email us or call us? Who is the secondary contact in our office if the lawyer's not available? What should you do if you need to reach us in the event of an emergency? And what type of behavior is not going to be tolerated in our office? We also take the time to walk through what is the clerk's role? What is the value add to the client by way of a lower hourly rate when a clerk is working on the file? What is the level of supervision for the clerks on the file? And then the fact that we are not going to tolerate any disrespect to the lawyers, but also to the frontline staff and to our clerks on a file, because we're all working together as a team and we're all trying to assist this particular client with whatever it is we're doing for them. So if there is some sort of behavior like that, then it's generally not a surprise to the client that we would terminate the retainer, because they were very well warned that this was not going to be tolerated. Now, further, this speech is very detailed with respect to our retainer agreements and the way that we process money in our office. So the lawyer themselves is giving this speech, and they are walking through the fact that we bill on a monthly basis at Law, what this bill is going to look like, how to make payment, why it's important to maintain the retainer to allow for uninterrupted work on their file. And because that lawyer is explaining it themselves, we've just found that this really cuts down on all the miscommunication that potentially can occur, right? Personally, I actually go a step further and I give them an example from i.e., if the retainer level is $5,000, then I'll say to them, okay, in the first month, we use $3,000 out of your $5,000 retainer. So tell me, how much will I expect you to pay to bring that retainer back up to $5,000? And I want them to actually answer that question to me, because a lot of times people have this idea that they're only going to pay one time in the beginning, or that they're not going to need to top up their retainer until you've hit zero. And that's not the way that we work in our office. I need them to understand that they're going to be paying monthly, and sometimes for a very extended period of time, and sometimes a significant amount of money per month, depending on what it is that we're doing for that client. But of course, sometimes despite best efforts, people are not responsive to your instructions, suggestions. They don't respond to the retainer top-ups. And we decide that, okay, enough is enough. We actually do need to terminate this retainer, unfortunately. That needs to be well in advance of any upcoming event or limitation date or deadline on the file. So again, there's not normally a lot of surprise if this does occur, because the client was so well warned throughout the process. And that speech was so very detailed that they can't say, oh, someone forgot to tell me that. Oh, nope, I missed that email or something like that. We just have cut out all of those possibilities right from the get-go. Now, if someone refuses to pay your fees, like Amir was referring to, it's possible to bring a solicitor's lien against them. I'm not going to touch on that because I've never had to do it. Because of the fact that we're billing monthly at our office, then that means that any amount that's going to be owing to us is going to be relatively minor. And thank goodness that's never come up as a possibility for us. But if that is something that you're considering, then you should know that you cannot prejudice the client by withholding their file for non-payment of fees. Okay, so now that we've talked about what would constitute good cause to terminate a retainer, now we have to move on to what's reasonable notice. So as I said before, the client can't be prejudiced, and it's difficult to have a sort of hardline rule about what would constitute reasonable notice, because obviously if someone had to retain a new lawyer and prepare for a trial, that's going to be a lot more difficult than if someone is just preparing for, say, an initial case conference, an initial mediation meeting, or something like that. So I think a common sense approach here is really necessary. But in general, our sort of rule in our office is that we want to be about 6 months in advance of any possible deadline, limitation period, event, etc., anything major happening on the file, because we feel like that would be more than sufficient time for the client to be able to go out and find someone new. Because of the fact that the courts have been greatly slowed down and delayed during the pandemic, at least in family law, that quite frankly has become easier because we're not getting court dates, 3 or 4 4 months out. We're getting court dates still 6, 7, 8, 9 months out. And so it does allow a little bit of lead time on these sort of very important and highly litigious files that's going to allow you to give them that amount of advance notice. Okay. The other thing that we do if we're terminating a retainer is that we prepare the file immediately for transfer either to the client themselves or to their new lawyer. Of course, it's possible to charge for the preparation of the file for transfer, but we don't make it a practice to do so. If you're going to do so, then that should be outlined in your retainer agreement. We also confirm to the client that we are happy to speak to the new lawyer if they have any questions or concerns at no charge on the file. All right, so now that we've decided that we are terminating the retainer, then the first thing that we need to do is actually send that termination retainer letter. And that's a very important letter. And while you could just send it out, quite frankly, and that would be the client's notice that the retainer is being terminated, I'm going to suggest that a smoother way to do that and the way to ensure a more satisfied client at the end of the day is to have either an in-person or a telephone conversation with that client prior to sending them the letter. Everything just seems a little bit harsher in writing, and we don't want a strong backlash. You know, someone saying, I had no idea this was happening. Why would you do this? They're going to be very angry, very defensive. Whereas I found that if you pick up the phone or you have the person in for a meeting, you start talking about the issues, then sometimes they say, yeah, and you know what? There are issues on my side as well. We obviously just don't work the same way. Hopefully the two of you can just agree to disagree essentially, and they can move on to a person who would be better suited for them and however it is that they personally like to communicate. The other thing that I do is I adjust the language of our precedent letter in the termination retainer letter to make sure that it's very plain language and it's going to be tailored to that person's level of understanding or comprehension, right? We want to make sure that the next steps that they need to take are going to be very plain to them. So regardless of whether or not you've been able to have a conversation, because sometimes that's just not going to be possible, perhaps the client is MIA, etc., you need to send the retainer termination letter immediately because you need to give them notice that the retainer is going to be terminated as of a certain date. You also need to confirm that you are not going to appear in court for them, but their next court date is going to proceed as scheduled. They need to either be self-represented or they need to retain a new lawyer. In family law as well, we need the client to sign a Form 4 if we are on the record for them. And sometimes we get them to sign that when they pick up the check with the remainder of their retainer funds from our office. Sometimes it goes to the new lawyer's office and they send it over to us. It just depends on the instructions from the client at that time. So your termination letter needs to have a couple of things in it. It needs to confirm the retainer is terminated and confirm the reason why. It needs to provide the client with the next steps and confirm what has been done for them thus far during your personal retainer. It needs to suggest other lawyers who might be able to assist them. It needs to remind them of any important dates or limitation periods. It needs to return any retainer funds or personal property to them. And it needs to confirm how long you're going to keep a copy of their file. Of course, you're going to do a final bill at this point, and you're going to include that final bill, I'm sure, with the retainer termination letter. I have I provided a draft, and I think that's with the materials and everyone can take a look at it. But it's very important to remember that this is just a very basic precedent, and it's really important to take the time and actually change that precedent to make sure that it speaks to the specifics of that particular file. It's not something to rush through. You don't want to forget to advise them of a specific date or something that they needed to do because they consented to it in a court order or something like that, right? Take your time, make sure it's done right, and then you most likely won't have any issues coming out of it. Now, sometimes this provokes a response from the client in which they ask, oh, please, can you reconsider? I don't want to terminate the retainer. I really want to stay with your office. And to be honest, I don't really recommend that you do that because there's obviously a reason why you're terminating the retainer. And that's because all of your attempts at communication and your attempts to have a good, productive working relationship have failed, quite frankly. And so highly unlikely that there's going to be a significant change in behavior. And so probably best that you simply proceed and actually go ahead and terminate the retainer. I also want to touch on the fact that sometimes the client themselves terminates the retainer. Again, I don't think that that would normally come to a shock to the lawyer on the file, but I suppose it's possible. Regardless, if that were to happen, then I would just follow the exact same model, prepare their file immediately for transfer, offer to speak to the new lawyer, make sure it's as smooth a transition as possible so that there's a level of professionalism in bringing that working relationship to a close, instead of emails back and forth about why this would occur, which unfortunately I've seen sometimes. Okay, so hopefully if you've done all of this, then this is going to have create a smooth transition to either self-representation or to a new lawyer. And Sean is back, so I'm going to guess that I'm up in terms of time. But before I go, I just want to touch very briefly to say that the other thing that we take quite seriously at our office is the fact that there are safety concerns sometimes when terminating a retainer, particularly in the family law arena. And so we do have a policy that we follow at our office when we're terminating a retainer and we think that in any way it could be potentially dangerous. And that is to keep the doors locked, operate on an appointment basis only. No one walks alone to their cars. People are not alone at court. And of course, if there are actual threats, then you do need to report to the police and bear in mind your duty of confidentiality when you're doing so. So hopefully that is helpful. And hopefully that means that you will never have to terminate a retainer. Thank you.
Thank you, Stephanie. That is extremely useful information. I'd like to actually ask Amer and Rachel to come on their cameras right now, because I'm going to put to them if they have any quick tips themselves on managing lawyer-client relationship, managing a breakdown or a termination. Amer, I'll start with you.
Sure. I think the only thing I can add is as you practice and pay attention to your clients or potential clients when you're meeting them. In my experience, the potential breakdown of a relationship is there are signs there at the outset of when you're getting into that relationship. And when I look back and I realized that there were clear signs that this relationship is not going to work out, and yet I ignored those signs. And so I think over the years, I got better at choosing the clients that I think the relationship would last. So that's something that I want to put in your mind. So I'll give you an example, real example, how it worked out for me. At the start of my practice as an employment lawyer, sole practitioner, someone referred to me a large client. They used to operate garage doors. They were manufacturers of garage doors and installation across Canada. And so they needed independent contractor agreements for all those subcontractors who would work across the country. And so this was obviously a major client, and if I was successful in retaining them, then it would be a profitable relationship for me, certainly. But as I was having that conversation, just like Stephanie was saying, have that face-to-face meeting with your client, and those were the times when the client would actually come to your office. So the client was sitting across the table, and I was explaining to them how the process would unfold, what the retainer agreement would look like, and I had my retainer agreement ready at that time. So the goal was we'll sign up and then we'll continue the relationship. And during that conversation, the client received, the potential client received the call from their accountant while I was talking to them, and then they put the accountant on the speakerphone, and the abrasive manner in which they spoke with their long-term accountant, it was completely disrespectful, and I observed it. And instantly I thought that this could be me on the other end, and I'm not the person who will end up in that, accepting that kind of relationship. And so when the client ended the call and I said, well, thank you very much, I don't think we'll have a relationship going forward, I withdrew the paper. And for a second, the client looked at me surprised, and then he immediately clued in, and he said, okay, fine, and shook his hand and walked away. So I think what I'm suggesting is that there are always signs that this relationship may not work out. And these signs could be in any kind. You know, they will not respond to you in a timely manner. They will not pay the fees in a timely manner, all of those things. So you are not the right fit for that client. Maybe another lawyer is. And that is an opportunity to walk away from that potential money. And I think that's the key, because we, especially when we're starting out, we are very reluctant to let go of a potential client that obviously has a good case. We think we can help. We think they can benefit. We think we can get some money out of it. And so we're very reluctant to let go of that relationship, even though when we see that there isn't a right fit there. So I think pay attention to those. And if you pay attention to those at the outset, you will not have problems on the other end. And I, in my practice, over 17 years now, I only had one case in my entire practice where I had issues with collection of fees, and never then. So that's my sort of advice.
Thanks so much, Amira. And Rachel, how about yourself?
So I totally agree with that. Trust your gut, and over time, your gut does improve significantly and tells you when to not take a client. Or sometimes your assistants are really useful and say, you know, you're going to hate this relationship later, and you're not going to want to work on this file. These are really useful things to listen to, especially when you're starting out. There always is more work, but particularly to my type of work and the people that I deal with, I often get clients who are referred by family members, or who come in, or their family members are the first person to contact me, or a trusted friend or professional of the older adult. And so it's really imperative for my practice that I make it very clear to the client and to their family, like, who is the client, how I'm going to be dealing with all of you, if I'm dealing with any of the other people at all, and to implement, you know, a little bit into my retainer agreement of what that's going to look like as well, so they have something to refer back to, and I can continuously, if it, you know, the issue arises again, point them back to this, and circle back to that conversation with them, and sometimes with them and their family member, like, or trusted professional. And I do like to try and establish a collaborative working environment to some extent where it's appropriate. And so sometimes it is really important to have those voices involved. But it is very, when you have them involved, you really need to make it super clear. So that's my tip about managing the client relationship. And one thing that I would say on fees, I haven't really had a problem collecting for the most part, because I usually do get, you know, I flat fee a lot of things where I can, and I do try to get those fees in advance. But where I had an issue with someone who just refused to pay me and kept ignoring my emails and my approaches, I took a bit of a creative approach and, you know, thought about the client as a person, and I sent some reminders immediately following a giving season. And to my surprise, they paid right away.
Wow. Good tip. Thank you, Rachel. So for our last subject today, we're going to be talking about how our communications between lawyers and clients can be improved by developing cultural competency skills and our understanding of EDI. And I'm going to hand this off to Sophia, who is the communications counsel here at LAWPRO, to start us off on the topic. Sophia?
Thanks, Sean. When I was in private practice, the firm that I worked at had a really broad spectrum of clients when it came to diversity. So people from different nationality, ethnicities, gender and sexual diversity, individuals who were neurodivergent or had disabilities, either be visible or not visible disabilities, clients who had just turned 18 versus clients that were approaching the age of 100. And I realized very quickly that diversity plays a role in the lawyer-client relationship, and especially when it comes to communication. So I'm going to touch on cultural competency, and then I'm going to turn it over to Rachel, who will touch on a few other items. So what is cultural competency? There's a few definitions out there. I generally like to go with the simplest one. Cultural competency is understanding what your own cultural values and beliefs are, and how it's different from other cultures. And by understanding, so I think there's two parts to that. One, understanding your own, and then understanding what the other values and beliefs are. Now, it's impossible to understand everything, but having a good general understanding that there are different values and beliefs depending on cultures and backgrounds really plays a role in the communication and component between the lawyer and the client. So I think the best way to illustrate this is using a few examples. And I'll start with the one where I was an art student many years ago, and I was with another female lawyer, and there was a client that was coming in to meet one of the senior lawyers. It was the first time we met him. When he arrived, I put out my hand to shake, you know, the usual shake hands, hi, how are you? And he immediately, instead of putting out his hand to shake my hand, he put his hand kind of to his heart and nodded and said, "It's really nice to meet you." I knew what was happening, so I retracted even before I can fully extend and kind of just placed my hands kind of in the middle. But the female colleague I was with, I think was confused. She did leave her hand out there. It took her a while to kind of retract and realize he's not going to shake her hand. And then when the senior lawyer came along, who's a male, he did shake hands with the client and the client shook back. Anyways, the meeting went fine. And when he was leaving, same kind of interaction, no handshaking. I knew this time not to put out my hand. After he left, the female colleague that I was with said, like, "Oh, that was really weird. Like, why didn't he, is it because we're women? Like, well, he didn't shake our hand." And I said, "Well, I think you think that he was being disrespectful, but in fact, it's the opposite. In his culture, he is respecting us by not shaking our hand and just putting his hand to his heart and acknowledging us." And so it's a simple example. And I think knowing that's that he wasn't being disrespectful helped me get on a good footing with him and drive a good communication. The first meeting was great, versus had I thought that he was being disrespectful, it might have impacted our relationship. Another example is body language. So different cultures, there's different body language can mean different things. I think head nodding is one of them. So in some cultures, head nodding like this can mean agreement. So if you're the lawyer, client is sitting in front of you and they're nodding with what you're saying, you might think that they're saying, "Yes, like I agree with what you're saying, Mr. or Miss Lawyer, please go ahead." Versus in some cultures, nodding can mean that they're listening to you, that they hear you. It doesn't necessarily mean agreement. And in some cultures, head nodding is not as typical as a yes and no. And it could be, the head could be moving, it's very flowing, and it's very easy to misinterpret what that means. In some cultures, there is no head movement. I've met clients who just kind of directly look at you. There's no smile. You are uncertain if they're listening to you. Are they not listening to, are they approving what you're saying? What is happening? I mean, the best thing is to avoid that type of misinterpretation and just ask the client verbally, what are the instructions? What do they understand? What do they not understand? And then document in writing and follow up on email and so forth. Another example of cultural competency is importance of some values over others. So, or religious-based laws. So for example, when I was doing will drafting, I knew in some cultures that they might leave inheritance more to a certain class of family members. So instead of everything equally to, say, 5 children, a client might come in and say, "I want to leave 75% to my son, and I want to leave 25% divided amongst my daughters." And I think knowing that helps drive the conversation more towards the law, the rules, what the outcomes might be, if somebody challenges it, rather than focusing on your own opinions and beliefs on how the assets should be divided. I had a few more examples, but I know we're short on time and I want to give Rachel some space to talk. So I think I'll just summarize cultural competency to say it's important to understand your own opinions and beliefs and not impose standards on your clients, not form inherent biases and pressure clients to make decisions that are more aligned with your own values and beliefs. And most importantly, I think a lot of people have touched on this, is document. Document what you thought, what the conversation was, follow up with email saying, "This is what we talked about today. Client, can you please confirm?" If it's a major decision, then get the decision in writing, signed and dated by your client. So I'm going to turn it over to Rachel. Rachel runs her own practice and focuses on seniors and families.
Thanks, Sophia. So there's just one thing that I want to add to the cultural competence discussion. I think it's really important that we all strive to increase our cultural intelligence, because, I mean, if you look at any kind of statistics of the makeup of Canada, or recently the 2022 snapshot of the profession, you'll see that, their diversity is increasing, so we need to really pay attention. And usually in that first meeting with the client or the first calls, you can sort of get an idea of what their values are, whether they come from a low context or high context communicating culture. So like, do they prefer direct or are they more sort of informal? in their interactions with someone. Like, do they walk around the topic? And obviously we are not going to walk around the topic because we're lawyers, but sometimes it helps to understand where they're coming from so that you can meet them where they are, and tailor your relationship and the way you and your firm manage your relationship with them to provide them with greater satisfaction and trust in your work. And of course, there are limits, and you have to sort of analyze what works for you and what you're not willing to do, and then respond appropriately. So other things that I'm going to talk about are language barriers and disabilities. And I'm probably going to talk a little bit quickly because, well, we're low on time. So when we're talking about language, it's useful to consider that there are over 7,000 languages in the world. This includes dialects, and some of those are dead languages. I don't know how many are dead languages, but in that number, that still leaves thousands of languages that people can continue to speak today. And many of your clients are going to speak a lot of different languages. And I've had issues where I have, my practice is always to involve a translator, because I do a lot of estate, I'd say probably 70 to 80% of my practice is within the estate realm. And so I don't really want my clients to be having their family member come in and translate for them in a language that I don't understand myself. So I will engage an interpreter as long as the client's willing to pay for it. And it's important to speak to that interpreter in advance to make sure that they know the terminology that you plan to use with your client. And to figure out, and sometimes you can't figure this out until your interpreter and your client are in the same room, do they even speak the same dialect? Is the client really going to understand, or is there going to be some additional time needed for them to work around and figure out what what both are trying to say, and how is that going to affect your work? I think for some practice areas, it may be appropriate to work with a family member to interpret. I couldn't say for sure. I think both the Law Study and LawPRO do have some guidelines on this. But for me, it's a no-go. Family members, I'm sorry, you just can't interpret for me. And then, there are clients who might have just limited communication. So I still, for those, I do like to get an interpreter. Sometimes in certain cases where I might have a mild understanding of the language or a mild ability to speak and communicate with them, or have a staff member who can step in to assist, then I'll do that, and we'll try and make it easier with sort of informal techniques like using cost-effective translation service. DeepL is a great one that I recommend. It does not have all the languages, but it is growing its database, and you can pay for a subscription relatively cheaply. And I mean, the thing to consider with languages is, unless you speak the language too, you're never really going to know for sure that they understand unless you have a professional translator who knows what to do. And who knows how to translate appropriately according to their own professional guidelines. I think I've covered the various ways to assist, having someone else in the office, using technology where appropriate. And if you are in a practice area where you can use a family member, make sure that they know what their role is and how they are to assist with translations, and they can't reinterpret what you're saying and say it to the client and then tell you whatever they've interpreted the client to say. And don't be afraid to say no to those clients and to pass them off to a lawyer that can assist them. As I said, was it 27.4% of licensees are racialized, or have said that they're racialized in their 2022 annual reports. There's probably somebody within your community who can help, within your legal community who can help, I should clarify. Now, when it comes to disabilities, this is definitely something that affects my practice. As we age, we tend to have additional issues that arise in our lives. And so there's always a mixture of things that I need to be kind of aware of. I'm not going to talk about, dementia and Alzheimer's specifically, because there is plenty of information already existing on this and how to deal with clients in those spheres. And I'm willing to have those conversations later, but also because I could talk about that for hours and hours and hours. But when you think of the word, excuse me, when you think of the word disabilities, I want you to consider what that means to you when you're meeting with potential new clients, and expand on what your definition of disability is and what that would be for your practice. Does the client have hearing difficulties? Are they part of the deaf community? Are they losing their hearing? Is there, do they use a particular communication aid? Are there other communication aids that you can use in communicating with them? I had a client who had come out of a coma. The client could not speak at all following their coma. The client knew sign language. I had recently taken a sign language course and by no means fluent, could not provide legal advice in ASL if I wanted to. I recommended an ASL translator, but we did find that the client was actually able to communicate with writing, and I did, you know, in these cases I do insist on meeting them in person, and with me speaking very slowly and the client writing out their answers on a notepad, we were able to get the job done, and of course document as much as possible. And that in this particular case, I was, even though the client had just come out of a coma, they were very forceful in expressing their goals and desires even in this way, so I was happy to move forward. Does your client have vision difficulties? Are they blind? Do they have deteriorating vision? Or undiagnosed diabetes can sometimes lead to severe vision issues. How is that going to affect your relationship with them? Do you need to read them everything? You may need to read them everything, or have something that can read them what you're doing, the letters that you're sending to them, or any kind of document that comes in. Is their speech impacted by a medical condition? So does your client have aphasia? They might not be able to understand spoken or written word due to things like traumatic brain injury, stroke. I've had a few of those clients, dementia, etc. Or they might not be able to speak in a way that's clear due to that's another medical condition or medical symptom. I think it's called dysarthria, due to, you know, brain or nerve disorders, alcoholism, sometimes throat cancer, or facial or head trauma, Parkinson's. So that makes them really difficult to understand. And so if they're difficult to understand too, how are you going to have that conversation? How are you going to have those conversations with them, those important conversations, and know that they're understanding if you don't understand them? And I mean, yes, paperwork and iPads, those are all great tools, but sometimes it's more difficult than that, and they can't write at all. So stroke victims can be particularly difficult because unless you get them pretty early on after their stroke, which is usually not the time when they come find a lawyer, unfortunately, you're going to have a really hard time communicating with them, right? They're at those stages when you can get at them. They are usually learning to deal with their new normal and undergoing therapy. They're not really thinking about whatever legal things they need to be thinking of. In my case, it's often, I need to have a power of attorney in place. I need to have a will in place. Those come later, and usually at the behest of their family members. And so I've had clients who, you know, their only method of communicating was by blinking. Can you imagine doing a Zoom meeting with somebody and trying to comprehend what their answers are when blinking and to get their instructions? It's kind of impossible. I mean, instruction getting when someone is from blinking is pretty well impossible. But you know, for those people, you do have to still meet with them, or if you want to move forward to decide whether or not that is a case that you can take on and that they can instruct you. I've also had clients whose communication was by squeezing someone's hand and to say yes or no, and you could ask questions. You could tailor ostensibly, you could tailor things to ask them the questions that you want or that you need if it is a situation like getting a POA done or a will, possibly. Like it's possible. It's difficult. It's going to take you a lot more time You definitely want to think about what information you need to get from other people and whether or not that's appropriate. Medical professionals, whether or not the client's going to be happy with you getting that information from their family members, medical professionals, or other people involved in their lives. And absolutely, again, this is a theme throughout this presentation, I think, for all of us: document everything as much as possible, send confirmatory letters and emails, and also consider other disabilities that we don't necessarily consider as disabilities so much, or symptoms of disabilities like paranoia, depression, unknown triggers that might just result in them acting a bit strangely during your meetings, long-term alcoholism or drug dependence, self-medication. All of these things can affect how a client communicates with you. And, you know, usually you kind of, hopefully you figure these things out early with good questioning of the client, and just general, like, if you get a lot of referrals, sometimes the referrals will sort of indicate something that you should know about the client particularly, and so you can kind of tailor your interactions in that way. So, I mean, ways to accommodate, obviously your first, maybe it's not obvious, but my first go is ask the client and try and get that information directly from them where possible. When family members or other health providers bring a client to me, frequently they volunteer information about the client. Like, you don't actually have to go and ask them for it. They just kind of present it to you, and then you take that and you go investigate. Do your research when you find out something, when you find out that they have a particular symptom or disability. Go do your research on it, figure out what are the best ways to communicate with this person, what can I try, and what am I willing to do to assist this client? And if you're not willing, that's okay. Like, you shouldn't take on somebody that you can't help, or that you don't think you can help appropriately. And you should say no. Like, there's very likely someone out there who will be able to assist them. So reach out to your colleagues. I mean, you could send them back to the Law Society Referral Service, but I've seen mixed responses with doing that. And if your goal is to try and really assist them, then try and find a lawyer who can actually assist them if you can't accommodate. And really, the biggest thing I think with dealing with a lot of files like this and a lot of clients like this is to give them more time, and to be prepared to give them more time, and not necessarily, like, I mean, we all want to make money, but a lot of people in these situations simply just don't have the money for the extra time that it takes. So act accordingly and do what's comfortable for your business, but also think about your client. Okay, I will stop now because Sean is back. And Sean, you're muted.
Sean, you're muted.
Sorry, thank you very much. Thanks so much, Rachel. And just to reiterate what all of the speakers said today, your interactions with your clients are going to be very personal. They're going to depend on your workflow. They're going to depend on your preferences. And so everything that we've spoken about is some advice. There are some options. There are some things to think about, but obviously it will depend on how you build your practice and your relationships. So we do have a few questions. We're almost at 11, but if everyone will hopefully permit me to go a few minutes over, we'll try to get as many of these questions as possible. There were a few questions about the social engineering elements of an initial retainer that I spoke to at the beginning of the program. I just want to say off the top, for additional information, I do encourage everyone to check out our social engineering toolkit, which is available at practicepro.ca, and the link is in the chat. But there were a couple of questions specifically on the matter of whether or not trust account information needs to be included within a retainer. I know one individual said that they considered that information to be private and were reluctant to include it. Someone else asked whether an email address was sufficient if they were going to be using e-transfers, whether rather than any kind of wire transfers. And so to clarify that, what LawPro is hoping that you will do is include within your retainers or in an initial early agreement information on how you are going to be accepting funds and how you are going to be transferring funds. So if you expect that that will be a large amount of funds that will require a wire transfer, then we encourage you to put that wire account information either within your retainer or within another agreement that you decide upon early within the relationship, because the earlier you get these things in writing, the less likely it is that a fraudster will be able to interfere and alter these details. So if you will only be accepting funds from your client by check, for example, all you need to do is put into your retainer or written agreement that is how you will be accepting funds, and you will not be accepting funds through any other method unless you have a different agreement with the client. Same with e-transfer. So it will be personal. It will depend on how your relationship with your client moves forward. It will depend on how much money you are expecting to receive from your client. But what is important is that however you are going to be receiving those funds, those details are put in writing as early as possible, and that will allow you to comply with LawPro's requirements. So we do have a few other questions here. I'd like to ask Stephanie to come back because I have a couple of questions for her. The first question is with regards to, do you have any tips on how to, quote, cross-examine clients to elicit information if you think they are either misrepresenting or misremembering the information that they're giving you?
Oh, for sure. So normally I like to accept their story as it's told to me in the initial consult, and I ask them a lot of open-ended questions so that I feel like I've gotten their full version of the story. And then when it comes to, who forgot to take out the garbage in their relationship, I don't care. What I'm worried about now is what do the finances say? And I ask them immediately to go and get me that financial information. And if they're saying, oh, someone stole money from the line of credit, someone did X, Y, or Z, and I'm owed money for that, then I say to them, like, what the court is going to want is actual evidence from you. So you go and get me your best evidence, and then we're going to take a look at it, right? And then sometimes there's zero evidence, and sometimes there's a lot of evidence, right? And then at that point, if it's a hard discussion to be had, then I sit them down. And to be honest, I think the easiest way, particularly if you're a younger lawyer, is to blame it on the court and say, well, wait a second. So you have to understand that in family court, it's going to be a he said and she said, or some sort of version of that situation. And so if we don't have any evidence, then our claim is going to be weaker. And you have to understand that because there's nothing to back up your version of events. And so you need to think about whether or not that claim is going to be successful, and whether or not, how much money should we put into advancing a claim, which may not be successful at all. And that's ultimately a decision that the client has to make. And sometimes they do it on principle basis only. And sometimes they don't.
Thanks so much, Stephanie. And actually, I have one more question for you. And the question is, how do you handle clients who approach you without giving enough lead time or are not responsive? Do you have a set amount of non-response time to disengage if they're not getting back to you, or is it on a file-by-file basis?
I think it does have to be on a file by file basis to some extent, but I will say that a lot of times people show up and say, oh my gosh, I've got a motion, in 2 weeks from now, I have to go to a case conference, something big is coming up and I don't have a lawyer and I need help, et cetera, et cetera. I'm happy to sort of corral the troops and get something done for them. But I will say that if it's an urgent situation, then they're paying the entire cost that we're anticipating upfront. Because if they don't have, $10,000 or whatever it is that we need for that event, they're not going to have it next week, right? It doesn't matter what they tell you. If they don't have it right now when it's urgent, they're not going to have it later on. So if they have the money and if they're serious about it, then, we can always corral the resources in order to assist them most of the time. But also you have to be very realistic about what your office can do. And certainly there are times we refer them out to say, we don't have the ability to bring an urgent motion this week. All of us are in court or whatever else is happening. And so we can only take on a file if we can represent them to the best of our ability.
Thanks so much, Stephanie. So I got another question here. I'm going to put this one to Amer. Amer, what would you say are your best practices if a client just suddenly stops paying, especially if they after received a large invoice? If there are certainly discoveries or mediation or things that went out the door and suddenly they stop paying, what is the first step to take?
So my practice may be different than other people, so I'll just tell how I deal with it. If the relationship overall is good, so in terms of receiving instructions and communication on substantive matters and stuff like that, and if the only issue that has arisen is that the fees are not paid, then my first reaction is that I don't get offended by it. My approach is to pick up the phone and talk to the client. And I think a conversation, is important, not necessarily an email, even though you can send an email to have that conversation. But I'll have a conversation to say, okay, I sent you, X amount of dollars, an invoice, $50,000 invoice. Did you receive it? Number one, and then ask them why has it not been paid in as politely as I can, and then listen to their response. With respect to, and especially, most of my work was in employment law or commercial litigation. So mostly when the issue is only about the payment of that specific invoice, I feel that in my experience, I've always been able to resolve it. So listen to the client and find out what is their concern. Is it their inability to pay that entire fee lump sum? Are they trying to arrange payment of that fees and whatnot? And then you work, I tend to work with my client and say, okay, this is how we can resolve your financial situation. But if the concern obviously is that they're not satisfied with the service that they received, and they're unhappy with the amount of fees and they believed it was beyond their expectations or anything like that, then there a deeper conversation needs to be had, either in terms of explaining to them what the invoice is about, answering their questions, and see if they're satisfied. And at the end of the conversation, if I'm not satisfied or they are not satisfied, then it turns into whether there can be an ongoing relationship or not, and then you get into that. So that's sort of a broad answer, but I don't get offended by only because the fee is not paid or one specific invoice is not paid. And so I get into a larger, deeper conversation with the client and try to figure out a resolution. That's sort of my general approach.
Excellent. Thanks so much, Amir. And I think that brings us, we're 5 minutes over, so unfortunately we won't be able to get to all of the questions, but you can send your questions to me at sean.erker@lawpro.ca if you would like any follow-ups on the content that we discussed today, and I will do my best to answer those questions. Thank you everyone again for attending, and thank you to all of our speakers for this excellent program. This program is worth 90 minutes of professionalism of CPD, and it will be available online in approximately 2 weeks on our YouTube page. Thank you again to the TLA for hosting this program, and we hope to see you next year for our future programs. Thank you again.